Hello and welcome to One and All Present. My name is Lakshaya and I'm an intern at LEXIS and Co. The topic for the day is right to private defense. Private defense is a very essential key to protecting oneself from crimes which can cause serious harm to their property or themselves. Under the Indian Penal Code, Section 96 to 106 states the law relating to private defense of person and property. These actions give a man the authority to use necessary force against an assailant or wrongdoer in order to protect one's own body and property, as well as the body and property of others. When immediate assistance from the state machinery is not readily available, he is not accountable in law for his actions. According to Section 97, there are two parts of private defense right: private defense of the body and private defense of property. The body can be one's own or someone else's, and property can be movable or immovable, and it can belong to oneself or someone else. The first rule of criminal law is self-help. For the preservation of one's life, liberty, and property, the right to private defense is unavoidable. It is a man's natural right. However, the type and amount of force used are strictly limited by law. The right of private defense refers to the use of force to protect one's property and person. It is a man's primary responsibility to assist himself. Every free country citizen must be taught the right to self-defense. Every legal system recognizes the right, and its scope varies in direct proportion to the state's ability to defend the subject's life and property. The state's first responsibility is to safeguard citizens' lives and property, yet no state, no matter how wealthy, can afford to assign a police officer to track down every criminal in the country. As a result, the state has granted every person of this country the right to take laws into his own hand and ensure their safety. Nothing that is done in the exercise of one's right to private defense constitutes a crime. The right of private defense will absolve the person of all guilt even if he causes the death of another person in the following circumstances: if the disease was the actual assailant, if the offence committed by the disease that prompted the exercise of the right of private defense of body and property falls into any of the 6 or 4 categories enumerated in Section 100 and 103 of the Penal Code. When an act that looked otherwise be an offence is not that offence due to the youth, lack of maturity of understanding, unsoundness of mind, or intoxication of the persons doing the act, or any misunderstanding on the person's part. Every person has the same right of private defense against the act as he would have if the act were that offence. If done or intended to be done by a public worker operating in good faith under the colour of his office, there is no right of private defense against the conduct that does not reasonably induce the apprehension of death or grave harm, even if such act is not strictly justifiable by law. The right of private defense of the body extends, subject to the limitations set forth in the preceding section, to the voluntary infliction of death or other harm on the aggressor if the crime that prompts the exercise of the right is one of the following. First, any assault that could reasonably lead to the belief that death will result as the result of the assault. Second, any assault that could reasonably lead to the fear that serious harm that will result in the result of an assault. Third, an assault with purpose to commit rape. Fourth, an assault with the goal of satisfying an abnormal craving. Fifth, an assassination attempt to the purpose of kidnap or abduct. Sixth, an assault that will goal of wrongfully confining a person under conditions that may be reasonably cause him to believe that he will be unable to seek relief from public authorities. If the offence is one of those listed in the preceding section, the right to private bodily defence does not extend to voluntary infliction of death on the assailant, but it does extend, subject to the limitations set in Section 99, to voluntary infliction of any harm other than death on the assailant. The right to private defence begins with the reasonable apprehension of bodily harm emerges from an attempt to threat or conduct the offence, even if the offence has not yet been committed, continues as long as such apprehension of bodily harm exists. The fear of risk must be reasonable, not irrational. For example, even if armed with a lethal weapon and the ability to kill, one cannot shoot an enemy from a considerable distance. This is due to the fact that he has not assaulted you, and hence there is no realistic fear of attack. To put it in another way, there is no attack, hence there is no right of private defense. The following must be evaluated in order to justify the exercise of this right. First, the entire mishap. Second, injury sustained by the defendant. Third, threat to his safety is imminent. Injury sustained as a result of the accused action is the fourth one. And last but not the least, whether the accused had enough time to seek help from other authorities. The right to self-defense is a powerful weapon in the hands of every person. This right does not pertain to vengeance, but rather to threat and imminence of an attack. However, people have the tendency to abuse this right. It is extremely difficult for a court to determine whether its right was utilized in good faith. That was all. Thank you and have a great day.